Assault on a security officer, it states, on or about May 29th of 2025 in Jefferson County, Texas. That it carries with it up to 10 years in prison and a fine up to $10,000. Paragraph 2 of the indictment states that you were previously convicted of burglary of a habitation in the 252nd District Court next door on August 12th, 2020. If that is true, then if you're convicted of this third-degree felony of assault on a security officer, it then is enhanced to a second-degree felony punishment, which carries with it no less than 2 nor more than 20 years confinement in prison and a fine up to $10,000 can be assessed.
This is where things escalate fast. What started as a third-degree felony just got enhanced to a second degree, all because of a prior conviction. That's how criminal history works in real life. Your past doesn't stay in the past. It follows you into sentencing. Suddenly, the stakes double, up to 20 years.
Do you understand what you're facing with all of this, sir?
No, sir.
Okay. Okay. What do you have to say?
Judge, he has created a conflict of interest for me. Over the weekend, I received a notice from the State Bar of Texas that he's filed a grievance against me.
Why?
Why?
Because he's not a sufficient counsel, and you are not my judge.
All right. What else? Anything else you want to say?
It just creates a conflict in our best.
Well, see, what the thing is, he could pull that forever.
And now we've got courtroom tension. Filing a grievance against your own lawyer? That's a serious move, but it doesn't automatically get you a new attorney. Courts look at intent. If it's done in bad faith just to delay the case, judges shut it down fast.
Everybody.
Understand?
I mean, he could go on for 100 years like that's a master plan that doesn't work.
I don't know if that's his plan, but I know
Well, it doesn't
definitely
matter.
I cannot represent him.
Well, what do we do if he pulls the stunt in every case?
I can't answer
Well-
that for it. But I know.
Well, I mean,
know
that's
bar-
not the way it's meant to be. What's the good cause for this allegation?
Because he's
How did he do that?
when he puts me on the defensive by filing a grievance against me.
I know, but
he's made me.
but if they're in bad faith, that doesn't matter. He said he hadn't figured out some master plan that works. That doesn't matter. It won't work. Is there any good reason that he would have had to have filed that?
No, sir.
Yes.
Then I'm talking to him, sir, Mr. Rude. No, if it's not, then it's in bad faith, so it doesn't cancel. Because it can be, we can do this all day long, and that's not the plan where you stall. Who is it where would this end if they were able to do this? That's why it's not allowed. It's not allowed if it's in bad faith.
I don't know where he's going from here, but I do know that it creates a conflict for me. And
I know, but who would it not create a conflict to in the scheme of the whole universe if this was allowed to be filed in bad faith?
I don't know what he's going to get forth. He may never file another. I don't
All
know.
right.
I don't know.
Well, maybe. Do you want to represent yourself though in this?
Yes, I can. Yes.
All right.
Represent myself.
All right.
I'll say
All right. Then you will
with my judge, Raquel West.
That's not the case you're in, son. You're in this court. So you're going to deal with me on this. That's the way it works.
Okay. Set a trial date.
Yeah. Do you know one thing? We want to make sure that you understand this. Generally, people who represent themselves don't do a real good,
Wait, did you catch that? He wants to represent himself. This is one of the riskiest decisions any defendant can make. Legally, it's allowed. It's called pro se representation. But in reality, it's like stepping into a professional boxing ring without training.
have a good success because generally the people who are the lawyers have gone to law school, have a law degree, have achieved a level of quality of education and passed the bar exam and have some experience to get in the felony court. All of those are important aspects in successfully handling a case. Do you understand that?
Yes, I've done all my research and I know all the laws.
Yeah. What is section 22 of the Texas Penal Code, if you know all the laws?
Section 22 of the Texas Penal Code. That has nothing to do with my case.
I'm asking you, said you know all the
I
laws.
said
What
I
is
know
that?
all the law to my case.
Mhm.
To my case. Like there's no proof beyond any reasonable doubt that I committed these acts with any criminal intent. If I put in a motion to quash these indictments, would automatically be quashed.
Well, we'll do whatever it is you need to do,
Okay.
but you're asking for a jury trial though, right?
Yeah, set a trial there.
Then we'll let a jury make the decision. That's the way it works. But do you understand there are pros and cons? This is really important that you have to tell me.
Yeah, I know a lot of
You've
things,
thought-
Briggs.
Can I just finish my sentence?
No,
This exchange says a lot. The judge is trying to warn him calmly, clearly about the risks, but the interruptions, the confidence, the pushback, that's a dangerous mix.
you really can't because you're really disrespectful.
Oh, I'm the one that's interrupting you? Okay. Oh, well, nonetheless, the law says you have to understand that there are,
I don't understand this case because I didn't do it.
that doesn't matter. The grand jury indicted you and had
Yeah, the grand
evidence.
jury has evidence that are
Are
non-sufficient.
you going to just interrupt all the time?
Because you're not.
Can I just, would you be just so kind and respectful just to let somebody complete their
Dude,
sentence and then you have a fair
so I can
opportunity?
beat this case.
All right, all right. If that's, we can do this all day long. But your final answer is you want to represent yourself. You understand?
Yes, sir. Yes, sir.
You're going to be required to know the rules of evidence, the code of criminal procedure, the penal codes, be prepared for that. If you don't know that, then generally people are at a disadvantage. Do you understand? All right. If you decide at any time you want to get somebody to help you, let me know immediately and we'll get it done immediately. Okay? All right. Anything else you want to add?
Nope.
All right, then we'll set it for trial. Thank you. All right, Mr. Campbell, in cause number 25 CR 558, you entered a plea of guilty to this second degree felony of aggravated assault with a deadly weapon. In this case, Mr. Dusler is here representing you. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? State.
None from the state.
And the defense. All right. It will be made a part of the record for all purposes. The agreement here is whatever sentence shall not exceed a cap of 10 years confinement in prison. So this is a deadly weapon used. So our options here would be deferred or unadjudicated probation up to 10 years in league, or confinement of no less than 2 nor more than 10 years confinement in prison. Regular probation is not an option in this case. Is that all? Does everybody agree, since a deadly weapon, namely a knife, was alleged to have been used in the commission of this offense? All right. State, do you wish to go forward or do you want to waive and let the state and then come back? You have a chance to open and close.
I'll waive the right to open, Your Honor.
And by the way, Mr. Campbell, you get credit for time served. I'm looking at 153 days credit. Is that about right that you figured? So that's about 5 months. Anyway, okay, go ahead for the defense, Mr. Dusler.
Your Honor, he's asking for deferred adjudication of probation. The pre-sentence report pretty much sets out.
Now we shift into a completely different case and tone. This one involves a deadly weapon, which changes everything. Probation becomes limited, sentencing gets tighter, and the judge has far less flexibility.
What happened, according to him. It was a stabbing. He does admit responsibility for the stabbing, but he's not saying that it was justified, but he's saying that he felt like that he didn't really have much other choice. The victim and he had been hanging around the Salvation Army for quite a while, and he mentioned that this victim had threatened to stab him and had been bothering him for many, many days prior to this incident. In fact, Mr. Campbell even went to the Beaumont Police Station multiple times to report that.
Who did you talk to over there?
Detective Armstrong.
Armstrong? What did he say?
He told me to protect myself. He couldn't do anything about it. He just told me to protect myself.
Okay. Looks like there's video of this.
Yeah, he doesn't, dispute that it happened. He just felt like that when the detective advised him, to protect himself at all costs, that he felt like that was what he needed to do to protect himself. He's got a history, many of it was a long time ago, 20 years or more ago, when he was a teenager. He feels like that he could successfully complete probation, and that even though sometimes these things are not justified in his mind, he felt like this was the best thing for him to do at the time. He regrets that it happened, but he would like the court to give him an opportunity on probation to prove that nothing like this would happen again. That's said pretty well.
Let me look at, I'm looking at the pre-sentence report by Mr. Dusler and also Mr. Campbell, make sure that we got all this. It looks like it dates back to 1993, so that's 32 years. And it looks like in Pinellas County, Florida.
Yes, sir.
Correct. You were placed on 3 years deferred or unadjudicated probation for aggravated battery back in 94. Then that was revoked. And then you were placed on, looks like they found you guilty and placed you on regular probation thereafter in February of 95. Then that regular probation was revoked about 5 months later in July of 95, and you were sentenced to 1 year's confinement, ultimately. And that looks like your first felony conviction. Then it looks like in January of 97, you were convicted, sentenced to 45 months and 15 days confinement for aggravated battery. And again, that was in July of 97. Then in 2002, you were convicted of uttering a forged instrument out of Pinellas County. Some of those methods of describing offenses in the old days that we don't use much anymore. Uttering a forged instrument is an interesting thing to say because that's not the way we use the words now, and it's in their usage. Uttering is generally a sound like communication, not something that would be misusing and uttering here a forged instrument would be passing a forged instrument. That's the way we used to, that was the old days of saying it. And you were convicted, and that looks like that must have been a misdemeanor, but it's showing up as a felony. Then there's burglary of a conveyance. And I presume that must be a vehicle again, probably, or a motorhome or something. In 2002, out of Hillsborough County, Florida, you were sentenced to 36 months probation. That was revoked in 2003, and you were sentenced to 56 months confinement. Then in 2002, you were also placed on probation for grand theft out of Hillsborough County. That was revoked in 2003, and you were sentenced to 56 months confinement. You were also convicted in June of 2002 and 36 months probated for illegal possession of burglary tools out of Hillsborough County. That was Florida. That was revoked, and you were sentenced to 56 months confinement in 2003. In 2003, when you were revoked on those last three convictions, it looks as though you were sentenced to probation on that same day of 10 years for burglary of an occupied dwelling out of Hillsborough County, Florida. That was revoked in 2012, and you were given credit for time served in the county jail. You were also convicted in May of 2003 and placed on probation for grand theft. That was revoked on June 29th, 2012, and you were given credit for time served. And in 2015, you were sentenced to a year confinement, convicted for retail theft out of Pinellas County. And then finally, in 2019, you were convicted and sentenced to 13 months confinement for theft with 2 or more prior convictions. So I'm looking at, correct me if I'm wrong, everybody. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 felonies, convictions, including aggravated battery twice.
I believe that's correct, Your Honor.
And then the others are theft related, burglaries, crimes such as that nature. Okay. So your criminal history is bad. And let me ask you here before I let the lawyers talk. According to this pre-sentence report, you, the victim was lying on the sidewalk when you approached him and suddenly stabbed him multiple times, saying, "See now, bitch," before running off. And they, later the police were able to figure out who you were and saw you walking northbound on Magnolia. You had changed your clothing. You were no longer wearing the same jacket and ball cap and backpack as had been observed earlier. And what you were wearing on the video that they looked at. And so they detained you. And then you stated he had been talking, well, vulgarity for weeks, is your explanation.
And right then he was too.
Yeah. Okay. You were taken to the Beaumont Police Department and you stated you were homeless, you slept near the Philadelphia church. You had called the police several times regarding people from Salvation Army who have harassed you.
Including him.
But nobody had ever physically assaulted you. You confronted the victim because he had been bothering you. You admitted stabbing him with a pocket knife, but claimed it was in self-defense. I had to protect myself. When asked if the other person had a weapon that you stabbed, you said you did not see any weapon and that he was unarmed and sitting on the sidewalk. And your version essentially was the guy had threatened to stab you and had been bothering you for several days. Looks like that's okay. So I get a sense of what the defendant's contention is. So what says the parties?
He's asking for a verdict.
I know why. I mean, he's got a rich criminal history and a violent crime. And what about the circumstances of this case? I mean, the guy the victim is stabbed, and he's lying on the ground. And words are not provocation enough under law. Somebody says bad things to you, they have to make some overt act to coincide with that, because people sometimes have bad taste and are reckless in their statements to others. But that's not enough to stab somebody and almost kill them. I mean, it has to be defending from aggression, but he's sitting on the sidewalk. Or he's laying down on the sidewalk. What's all that about? How does the defense explain that away? I know it's not a defense, but what's good about it?
Well, there's nothing good about it. I obviously wasn't there, so I don't know what happened.
I'm just reading the report like you do.
I'm reading the report as well. And
What's good for the defendant?
What he tells me is this was an overreaction. It was a foolish mistake at the time. He realizes in retrospect he shouldn't have done it. Most of his criminal history is 20 and 30 years ago. That's the reason why he's asking for a chance before this court. Pretty much everything. Huh?
It been months. It wasn't just weeks,
Yeah.
days, just months.
Or he was just going
I went to the police station about a month before this. try to get the police to do something about it.
But what were they supposed to, what do they
At
do?
least talk to him or something. I don't know.
But nonetheless, the, the law states that words are not enough for you to commit aggravated
That's why you've
assault.
been doing
There
it.
has to be an overt act at the time to cause you to protect yourself. He's laying on the ground asleep, isn't he?
He was sitting down.
Sitting down. Okay. Did he have was he brandishing a knife or something? No,
he
a
was-
weapon?
He was talking. He was
He was just
he
speaking.
was still speaking. Yeah.
Okay, but
Yes, sir.
unfortunately, people who speak and use poor taste or even threatening, that's not enough to take something out and stab them under the law. Because unfortunately, people do often say things they shouldn't say disrespectfully. That just doesn't give you the power to grab something and assault them with a stabbing instrument, which is capable of causing serious bodily injury or death. All right, what's they say?
Your Honor, given the fact that there was no provocation whatsoever, in this instance, he was unarmed. He was not fighting or making any sort of altercation. That coupled with all of, the history here and the evidence that every time he was given the chance on probation, it was then revoked later on. The state is asking for 10 years.
All right, go ahead, Mr. Campbell. Tell me what you need to tell me that helps me make my decision.
No, I tried to resolve the issue. And I'm older now, so 20 years ago when I was on probation, I wasn't trying to do probation. But I can do probation now. I'm older. I need to set a foundation for myself some kind of way because I'm not gonna be able to work after a while. You know, I'm 50 now. And I think I can do it. He gave it to me.
Okay, but what are we, I'm looking at, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9 convictions. Let me see, 10 convictions, right? Felonies and misdemeanors. Okay, so that's high and that isn't helping you. And then here, the circumstances aren't good. This guy could have died, you know, and he was just laying on the ground, and that's not a good thing either. But you know, mistakes have consequences. You've been to prison or facilities at least 10 times in punishment of acts that you had committed.
Prison's not helping. Put you in a mindset of protecting yourself all the time.
Yes, well, that statement isn't really good for you. It makes it sound like you've been to prison so many times, you're just plain dangerous now to be left out.
No.
That's what you're saying.
No.
I mean, that's not what you intend, but that's what it boils down to.
I'm harmless.
You're harmless?
Yes, no.
Well, I don't think the victim in this case thought that.
After what he put me through, I think.
Sir, he was laying on the ground. I mean, people shouldn't mistreat others and be disrespectful, but you don't stab them when they're just laying down. And
Right.
but you have to defend yourself.
I think one of the big problems,
Yeah.
that when I looked at this is that none of us really understand the dynamics in the homeless community. Well, you know, we can look at it and say it certainly wasn't justified. Their lifestyle and like I said, the dynamics of what goes on there, we can't really truly appreciate.
No, but they like all of us have to conform to the mandates of the law. And laying down, and you stab somebody who had said bad things to you in the past in poor taste. Poor taste is not a crime, unfortunately.
Your
It
Honor.
doesn't. We're talking about something that's life threatening here.
The homeless community is afforded the same elements of self-defense. However, I don't think that this was present here whatsoever.
No, I know it's clear it's not. It's just what do we do here? And unfortunately, it's criminal history is so What do you plan to do when all of this is behind you?
Work and stay out of trouble.
What do you
That's
do for a job? What are your job skills?
I'm confident.
A carpenter?
Yes,
Are you good at it?
I'm pretty good.
Oh, man.
Um,
All right.
I ran into a little money I can for fees and stuff. So I ended up getting a settlement.
Okay, in this case, court's findings are as follows. The court finds that the defendant has pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this aggravated assault with a deadly weapon, namely a knife. The agreement is a cap of 10 years imprisonment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. And there will be an affirmative finding that a deadly weapon and a knife was used in the commission of this offense. And I hope that you use more discretion. You have to defend yourself, but here, this was not the case under the law that fits your use of force that was capable of killing a person. You can't stab people when they're just laying down on the ground, not an immediate threat to you, but you do have to defend, you do need to defend yourself when they are. And this wasn't the case. Your criminal history does not help you. It works against you. And there could have been probably some of these prior convictions could have been used to enhance this indictment, which weren't done in this case. So the court finds under these circumstances, this is the appropriate disposition. You understand what has happened today, sir?
Yes, sir.
Good luck to you.